good morning to all of you and welcome to the University of St. Thomas School of Law for oral argument before the Minnesota Workers' Compensation Court of Appeals. The court appreciates the time spent by the law school staff, including Dean Kelly, Professor Wynn Campbell, Sally Dahlquist, and Devin Donarski for their help in arranging and preparing for today's oral argument, and the warm welcome extended to the court and our staff. We are also grateful to counsel for the parties, Mr. Jason Schmeichel and Mr. Michael Garbo, for their courtesy in agreeing to participate in today's oral argument here at St. Thomas. It's always a hard task preparing for oral argument. Coming to the Minnesota Judicial Center, but coming to a different location is even more difficult, and we appreciate the courtesy and cooperation of counsel. As we start here today for the oral argument, I ask everyone to either silence or turn their phones off. And also, I am inviting you to stay after the oral argument for a question and answer period of time with the court and counsel. Today's date is October 29, 2025, and the court has one case scheduled for oral argument. Risa Jenko versus Cleveland Cliffs, and AIU, or Arch Indemnity Insurance with claims administered by Gallagher Bassett Services, Inc., our file number WC 25-6610. Today's argument is being live streamed and recorded. We would ask counsel to speak loudly and clearly when arguing before the court this morning. The panel for today's argument are to my right, Judge Sean Quinn, to my left, Judge Kathy Carlson, and me, Judge Tom Christensen. We have experienced counsel before us today, but as a reminder to each of you, you are allowed 15 minutes to present your argument with a yellow card being presented to you at the 5-minute and 2-minute mark. When your time is run out, a red card will be shown to you. You will each be allowed 3 minutes of uninterrupted time before I interrupt your argument to ask the panel if a member has questions for you. Counsel is requested to keep track of their time allowed for oral argument. Any unused time may be reserved for rebuttal. Should the allotted time to a party be extended because of questioning by the court, opposing counsel's time will be extended. When you step to the podium, please identify yourself and the party you represent. Mr. Schmeichel, you are the appellant, I believe, so you can go to the podium. Thank you.
Thank you, Judge. Good morning. May it please the court, Mr. Garbo. My name is Jason Schmeichel. I represent Cleveland Cliffs and its workers' compensation carrier in connection with Ms. Risa Jenko's workers' compensation claim. I recall when I was in law school watching the Supreme Court oral arguments. I remember my takeaway, one of my main takeaways was those attorneys must have been really nervous. And I've been doing this now for 25 years, had an opportunity to argue in front of the Supreme Court, and have had dozens of Court of Appeal arguments, and I'm still nervous. But one of my mentors, Mike Forty, former partner of mine as well, now retired, said that if you aren't nervous, you don't care. So, briefly, the facts of this case, Ms. Risa Jenko, about 6 years ago, began working for my client, Cleveland Cliffs. She's a 38 or 39 years old now. Her job duties are actually kind of cool. If you've ever been up towards Outlet and you see on that hill that gigantic truck that's the size of an apartment building, she drove one of those, and she drove it around the mining facilities. And on a very cold day in January, she was experiencing the problem that some of the ice was freezing and it was keeping some of the debris freezing to the bottom of the dump portion of the truck. So she had to go in for what they called back scratching, which is they take a different sort of piece of machinery and they actually scrape off the stuff that's left behind. In the process of that, Ms. Jenko claims that she was jostled awkwardly in the cab of the truck, suffering injuries to her neck and her shoulder, her left shoulder, I believe. She's not returned to work in any capacity since that time. She's remained out of work since then, at least up through the date of the hearing a couple of months ago. It was deemed non-surgical, the nature of her injury. She's treated primarily, especially over the course of the last 18 months or so, with simple massage therapy and acupuncture. But importantly, she's not returned to work in any capacity. There are two main medical opinions that are provided in this case. One is my client's expert, Dr. Lauren Vorlicki, who indicates that in his opinion, Ms. Jenko suffered nothing more than sprains, strains from being jostled around, very temporary injury that likely resolved within a couple of weeks of the incident. Then there's an opinion from the treating physician saying that it's something much more permanent. The claim was the nature and extent or whether an actual injury occurred. And then the other primary issue at trial was temporary total disability benefits, wage loss, from the date of the incident up through the date of hearing. The judge, ultimately, the compensation judge, Judge Chang, issued his opinion, finding that basically rejecting the opinions of my client's expert and awarding the temporary total disability benefits as claimed. On appeal...
Counsel, I'm going to interrupt you at this time and ask whether Judge Carlson or Judge Quinn have any questions for you at this point.
Oh, thank you. Yes. First of all, again, thank you both for agreeing to be here. I agree. I was always nervous. Actually, even sitting here, I'm nervous. And so having an audience just makes you more nervous. So we really appreciate you being here. Mr. Schmeichel, I just want to hop right into this job search thing. In his memorandum, the compensation judge said that where there is unrefuted evidence of a continuing employment relationship, the employee's failure to conduct a job search is excused. And he cited the case of Carrion. Do you agree with that? Do you believe that's what Carrion says? And do you believe that's a correct statement of the law?
I very respectfully disagree with Judge Chang. I think Judge Chang created what it seems more recently when we're discussing these things maybe outside the courtroom. It's that case, and then it's also the Leal case that seemed to be interpreted by practitioners as having this bright line rule that says that if you haven't technically been terminated from your date of entry employer, then no job search, and that's it. That's it. Bright line, no other inquiry. And I don't think either of those cases say that. Leal is a situation, well, actually, here's what Leal says, which is where an employee has a reasonable expectation of returning to work with the employer. However, the employee may not be required to search for work. So it doesn't say that they're not required to search for work. And that was a very different situation in Leal. That was, I believe, a seasonal employee that had been laid off for a short period of time.
So then that leads me to my next question. Do you think assuming that an employee had a reasonable expectation to return to work with the employer, is there maybe some durational component to that? At some point, does it become an unreasonable expectation? And can you talk a little bit about that and maybe the timeline in this case compared to other cases?
Absolutely. And there's a number of cases over the past 15 or so years that this court has addressed, and they've identified as one of the factors the period of time. And that actually comes from, there's the Judith Weiss case, which is March 15, 2018, that talks about case law is held where there's evidence of a continuing employment relationship with the employer, and there appears to be a reasonable possibility that the employee might return to work with the employer, importantly, within a relatively short period of time. A judge may conclude that it is not reasonable to require a job search. And so if you look in the Carrion case, that actually was August 3, 1998 through December 28, 1998. So a period of approximately 5 months. And they go out of their way, the WCCA, this court goes out of its way to point out that she was repeatedly checking in with the employer saying, do you have work for me yet? Do you have work for me yet? And I believe this is the one where they finally said, we'll get back to you when we have work. And she finally, on her own, in January, after 5 months, started searching for work, which is now what we have here. And then we have also the Dennis Lorkey case, which is January 31, 2008, again from this court, that says that to note that a reasonable expectation to return to work with the date of injury employer must be accompanied by some action on the part of the employee which demonstrates the alleged belief in a continuing employment relationship. And then we have there's a John Kuster case, which is January 20, 2009.
Can you say the name of that case again?
It's John Kuster. And in that case, again, the WCCA made comment on the fact that it was a relatively short period of time. In this case, we have 2.5 years that she didn't search for work. And during that time, you might be asking yourself, what was she doing? And commendably, she became a full-time student. And she got her master's in social work. So she basically, that entire period of time, attended school full-time. There's no evidence in the record whatsoever that she was checking in regularly, that she was, calling up supervisors, HR, to see if there's anything that she could do in returning to work. And as I was prepping for this, I was going through the transcript.
I'm sorry, Mr. Schmuck, I want to interrupt you here. And I agree with everything you said about what the cases you recited say. There is no case that says that there's any obligation on the employer, at least that I could find. But should there be? I mean, the one thing I noticed in the record was there was a FMLA or something like a sickness and accident benefit letter sent by your client to the employee saying, you've been approved for sickness and accident benefits. We expect you to return to work sometime. And it was just like April of 2023, so just a couple of weeks later, because this letter was in March. But if you need longer, we need more, off work slips. And then that's it. And yet your client kept paying sickness and accident. I didn't see any off work slips. Is there an obligation on the part of the employer to do something too?
Yeah, and I've thought about that, Judge, because I don't know that there is. I mean, I'm not aware of anything in the case law that says that there is.
I couldn't find a case, but should there be?
I don't know that there should be. I think that an employee who has, and by the way, a reasonable expectation of returning to work, the ball is kind of in their court to say, hey, I appreciate you guys holding the spot for me. And here's what's going on, and I hope to be released. I'm going to be, but there's no evidence of any of that. I think it'd be hard pressed to have the employer, to put the onus on an employer to reach out to somebody who's on FMLA or on sick leave to constantly be asking for updates. And
but they say they want updates on workability.
Right.
And I didn't see that those happened. I also didn't see that your client said, we're going to cut you off if we don't get them either. So.
And that's the other thing I thought about with this, Judge, is that I have Cleveland Cliffs and then one other client of mine who I won't name, but they're wonderful employers. And and one of the ways in which they're wonderful employers is that they give a worker that they value every opportunity to return to work, provided that they can. And so they leave them almost indefinitely as technically an employee from a personnel perspective. But if this truly is a bright line rule, as a lot of practitioners claim it is, and as Judge Chang sort of interpreted it, these employers, like Cleveland Cliffs, being mindful of the ADA, of course, are going to say, we can hold your position for 30 days, but after that, we've got to find somebody else who can come in. We just can't have a payroll filled with people who may or may not come back, and we haven't heard from you. There's going to be, I think, an impact to say that if you keep them technically an employee, then they can sit out there and they have no obligations in terms of either returning to work or finding work elsewhere.
Right. So let's say we agree with you that this 2+ years of temp total, we don't have enough evidence of reasonable expectation. Is there a window where there was, or does this need to be remanded? What's the relief that you want here?
A window where there was a reasonable period of time.
Yes.
Where she should. Well, I think it's.
Is there evidence to support such a finding?
I think it's worth noting that she was never totally disabled from work, so that she always, and I think that you could look, Your Honor, for instance, when she began enrolled as a full-time student, which was almost immediately.
It was even a week before.
Yeah, and this had been, Judge Chang actually made a point of saying, in support of his finding that, hey, she'd already planned on going to school, and I really had to itch my head over that one, thinking, I think that reads kind of both ways on this. I think that she always wanted to go to grad school. This was not prompted by her injury. She always wanted to get her social work degree. And it was, boom, this is a perfect opportunity. She can be a full-time student. She's got benefits rolling in. She's making a claim for temp total disability benefits. And I think it's telling. I didn't notice this when I was putting the brief together, but when I was prepping today, on page 46 of the transcript, when asked by Mr. Garbo, is your job there for you? And she said, well, quote, well, nobody's told me that, but I'm probably not going to be able to drive a dump truck again. So she clearly, and then also, as I quoted in my brief, when I asked her, was it your plan to go to work in social work? She didn't just say yes, she said absolutely. And so she, one, knew that she wasn't going to go back she knew she wasn't going back as driving that truck again. And two, she had no interest in going back to drive that truck again because she got her grad degree and she absolutely wanted to work in that profession.
Okay, so back to the question though, which is there a window of time where, there was a reasonable expectation?
Based on, and in the issue of does it need to be remanded for more findings? Sure. Or I think that'd be easier to answer, Judge, if there'd been like a 3-month gap between the injury and her starting the full-time student. I would still say with the evidence that we have right now, when she enrolled in school full-time and was not totally disabled, and she claims, and she testified, that her condition from day one, it's always been getting worse and worse and worse. And she knew that she wasn't going to be able to, nor did she want to, return to work driving a truck. So I can't say with the evidence right now that there is any window that is justified for receipt of temp total disability benefits.
So I have a question. So would you agree that the standard of review is substantial evidence?
Yes. Well, I would also argue that there's a misstatement of the law. So there's an error of law. I think that Judge Cheng, again, respectfully, I think he overstepped the boundaries of what Carrion and the other cases along the cases that I cited today, what those cases actually say. That it's one thing to have a reasonable expectation, but there's more to it than that. There's always been more to it than that.
And assuming there's substantial, the standard is substantial evidence in the record, is there any evidence in the record from your perspective that establishes any period of time that the employee is entitled to temporary total disability? I think you've answered that, but
under the odd circumstances
be more
of this
direct.
Case, the reasonable response, Your Honor, of course, is to say, well, sure, there's about 3. But given the very strange sequence of events that we had on this, I don't think there's anything in the record that supports any period of temp total disability benefits. I believe my time is run.
I'm good.
question?
You asked my question. Thank you.
Okay, good.
Thank you.
Thank you.
Good morning. It's a privilege to be here. I'm Michael Garbo. I represent the injured worker, Risa Jenko. And I think it's wonderful that you guys are coming to the law school and, doing this for the students. I think that's really important. Thank you. I'm not as nervous as Mr. Schmeichel because I won at the court level. So, basically, the standard of review, I just wanted to throw that out there real quick and then circle around to some of the things that you were discussing with Mr. Schmeichel. And standard of review is findings of fact and order must be clearly erroneous and unsupported by substantial evidence, and it supports if in the context they are supported by. So they look at the whole the whole context of everything that was submitted, all the issues, and it's got to be clearly erroneous and unsupported by substantial evidence. The workers' comp judge, in his findings and order, addressed the medical evidence that was presented, and he clearly stated in his order why he did not believe or thought that Dr. Vorlicki, who was the independent medical examiner, his findings were not as solid as the treating physician. And he was very specific about it. Vorlicki said, well, it's a strain. She just suffered a strain in the neck and the shoulder and such. However, as it came out, the radiographic evidence, the MRI of her cervical spine showed that she had some bulging discs, and there was issues with the shoulder. So the doctor, her treating physician, I sent her a questionnaire to fill out, and she wrote a letter on top of that stating why she felt that Ms. Jenko's job of driving that enormous dump truck and getting back scratched where it's going like this could absolutely substantially aggravate that cervical spine condition. And we all know as workers' comp attorneys and such, you have bulging discs in your cervical spine. Maybe if you hold your head a certain way, you don't feel the pain or whatever. But when you try to sleep, you can aggravate, you get pain, you can't sleep good. And that was evidence in the record that she wasn't able to sleep good. Her description of the symptoms were clear from the date of injury, January 31st, 2023. She was very clear about, hey, she was kind of dealing with regions. I got pain in my shoulder, bottom of my neck, this, that, and the other. She was very consistent all the way through. And it seemed like during the middle of her medical treatment, they started focusing more on the shoulder. And again, as a workers' comp attorney, it deals with these kind of cases all the time. If the shoulder's not showing problems that's causing the radiation because her arm's going numb, a lot of times you look a little further upstream, and it's the cervical spine. So she had an MRI in 2020.
Thank you, Mr. Garbo. We have 3 minutes now.
Okay.
Judge Quinn and Judge Carlson, whether they have any questions.
I'm going to follow up with kind of the questions that Judge Carlson asked Mr. Schmeichel. We have Judge Chang's, let's assume we agree with you that there was an injury and that Dr. Vorlicki's opinion was rejected by the comp judge, and let's assume that.
But the standard isn't whether you agree.
Right.
It's was there a clear error.
Right, and let's say we agree that the compensation judge did not err in adopting the treating doctor's opinion over Dr. Vorlicki. There's an injury. But your client, to be entitled to temporary total, either has to be you can't work or you can work with restrictions, and if so, you should be doing a job search, with the exception you don't have to if there's a reasonable expectation of returning to work with this employer. What evidence is there to support the award of temporary total for basically 2.5 years?
Okay. The 2.5 year, well, first of all, the 2.5 year stretch, Risa Jenko had a couple different attorneys and such, so I come on kind of late. So there was continuances, there was, it might have even been stricken off the trial calendar while we're going through the process. So if it was Risa Jenko's, if it was her option, she probably would have had this thing 2 years ago, the trial, but due to the attorneys and such, these things drag out. But Judge, you mentioned something very important. When you're injured at work, and she clearly stated she's injured at work, and we've submitted workability reports and saying that, due to this condition, due to that condition, she can't go back to work. So she reported the injury, and they denied the claim. So when they deny the claim, they're not providing you with options. The employer holds all the cards about whether or not you can go back to work. Because she would have went back to work in a part-time basis. They never offered her a part-time job. They didn't offer QRC services. They didn't talk to her about, well, if you can't come back to this job, we'll look at retraining you. Because all those options are on the table. If an employee cannot return to work, maybe they can get retrained, they'll pay for it, they'll pay her wage, and then they'll give her a period of time to try to find a job. So there's all kinds of safeguards in there for an employee who's just languishing out there.
And I agree with you on all those
Right.
things. But, VRU offers QRC services for denied claims. We don't have that here, at least not in the record. A retraining claim certainly could have been brought, but as far as I know, at least in this record, it's not been brought. So she's entitled to temp total if she cannot work, period. Or she can work with restrictions, but she's looking for work and can't find any, with the exception of this reasonable expectation. Judge Chang went with the reasonable expectation theory, doesn't have to look for work, because she's still employed. And that's all he said. She's still employed there. And no doubt that's undisputed. She's
And he
still
cited the
employed.
case law.
All right. Is that the only support for ongoing temp total, that she's still employed?
Judge, you have tremendous experience in workers' comp cases. I don't know how long you practiced it before, but you know that if you have a denied claim, they're not going to talk to you about a retraining plan. They're not going to offer a retraining plan for you. They're offering her nothing. She's sitting out there without any money. She makes over $125,000 a year, and that's very, very good money for that area.
It's outstanding money. But
So she wanted to go back, Judge, but they're not offering her anything. And I heard a question about, should the employer have,
is there a reasonable expectation that she's going to go back to work at Cleveland, regardless of the job? Let's assume she can never drive a dump truck again. She said, I can't. That seems to be, and that she doesn't even want to. Is there a reasonable expectation, is there evidence of a reasonable expectation that she's going to return to work at Cleveland Cliffs?
based on the case law, yes, because you can't find, and you asked Mr. Schmeichel if there was case law stating what, given some factors, what a reasonable expectation could be, and was there a time limit, and was there a responsibility of the employer?
Sure.
Okay, so I can answer that in short order. One is, here's the reasonable expectation. She was injured, she reported the injury, and she wanted to go back to work. They would not let her go back to work. And it was stated by Mr. Schmeichel that she repeatedly contacted the job to say that, I'd like to go back to work. Do you have anything for me?
No, Mr. Garbo, where in the transcript or in the evidence is it that your client contacted the employer asking to return to work?
I believe she testified to that, and maybe it's not. Well, okay, Judge, you bring up a good point. Because it wasn't, Mr. Schmeichel did not focus on that at the hearing. Now we're having to go back and do the coulda, shoulda, woulda argument on things that were not delved into in the hearing.
Mr. Garbo, you stated it as a fact that your client was contacting the employer. I didn't see that anywhere in the evidence. So if you can point in the evidence where that is, that would be helpful.
Well, I believe Mr. Schmeichel stated too that she was contacting the employer.
No, he did not say that. And I agree with Judge Carlson. I did not see that in the record either. And what we have is, I can't work at driving dump truck, and I don't want to. I do want to go to social work. That's why I'm going to school for
She
it.
did not say that, Judge.
All right.
She did not say that. She did not testify that she wanted to do social work instead of her job. And she started doing the degree before she got injured.
Correct. But I mean, you're pointing out all the things, and you kind of phrased it, the woulda, coulda, shoulda stuff, but there isn't a rate training plan. There isn't a QRC. What we have is can't drive truck slips from doctors, which, okay, we all agree she can't drive truck. Those even ended in November of 23. And then we've got trial in April of 25. I don't see the evidence that says she's entitled to temporary total disability benefits.
Okay.
That's what I'm looking for.
Okay. So I will withdraw the portion of, it was my mistake. I thought it was in the record that she was stating she wanted to go back to work. But you want evidence of, her intention where she thought she still had a job. So, Judge,
expectation,
Expectations.
reasonable expectation that
That's
I'm going to
correct.
return to work at Cleveland Cliffs.
So her expectations. Judge, it's a completely different track. If they would have accepted primary liability and they would have been paying her benefits, then we're on the clock. Hey, they could have filed annoyed, attention to discontinue benefits if she wasn't doing anything, if she wasn't doing like a job search or making any movement. But we didn't have any of that governance because this was a denied claim.
So
Mr.
you're saying a denied claim has sort of a different level of proof required for reasonable expectation to return to work?
Well, I would hold that yes, that the difference would be, and again, Judge, we're speculating on something that wasn't really, delved into at the trial. But yes, I would say that there would be a different expectation for a denied claim as opposed to an accepted claim.
And Mr.
Go ahead.
Well, okay. I want you to just kind of focus on this question. Does an injured, regardless of whether it was denied or an accepted claim, and regardless of what the employer does or should have done, does the injured worker have any affirmative duty to show that there's an ongoing employment relationship or expectation of return to work, like contacting the employer, attending meetings, sending in disability slip? Is there any duty on the injured worker?
Judge, that's a very difficult question because there's so many underlying factors. Now, if you have an unrepresented, I don't know when she first got representation on this, but if you're,
Regardless of representation, is there any duty at all on the injured worker?
if that injured worker would get a QRC, which they have available through the state on a denied claim, then that worker would be enlightened to the responsibilities that they have to get the temp total disability benefits, or to be in line for temp total disability benefits once the trial occurs. However, well, because it's a denied claim, so you got to go to trial, Judge, to get primary liability. So if you're working with the state
Mr.
QRC would
Grimode,
let you know the things you need to do in order to
would you
be in line to
agree
get
that
primary total benefits.
The laws apply the same to injured workers regardless of sophistication level or a denied or admitted claim. The obligation to look for work is going to apply regardless of those things. Do you agree with that?
But Judge, you're not citing statute, you're not citing anything in the case law, because the case law says that if you're still employed, just what we were talking about, if you're still, actually, do you want me to give you the quote?
No, I'm.
Yeah, if you're still
I'm
employed,
familiar with the case law, but there's also case law that says that an employee has an affirmative duty to show an ongoing employment relationship, and I'm specifically talking about Lorkey. So, and I just want to know, do you agree with that an employee has an affirmative duty other than not being fired?
depends. It depends. I mean, what does that affirmative duty require? What are some of the minimal things that they need to do with that affirmative duty? We don't have case law on that. That's why we have QRCs. That's why you want to have a client that injured worker that doesn't understand the system to have a QRC. But if they don't understand the system, they don't get a QRC.
We're done. Any other questions?
No, but I'm afraid I cut off your question.
Go ahead.
Is there any evidence before us, you talked about the employee, at least we've looked at the evidence, and I've looked at it, and I don't see anything where your client contacted the employee.
I apologize for that. I misspoke.
And that's fine. Is there any evidence in the record that I may have missed regarding contact by the employer to your client?
No.
Thank you. Any other questions?
Thank you.
good.
Okay, thank you very
Thank
much.
you. Thank you for your oral argument today. It really helps the court understand the issues presented by this appeal. We will take the case under advisement and we'll issue a decision in 90 days. We are adjourned.